Morning. This is a morning that came a little later for me than it was supposed to have come. Unfortunately, slept through my alarm, so I am very grateful to be here, and grateful to be here in a fashion that I could speak with you. It's a great pleasure for me to be here in Armenia, to see many of you who are friends for many years, and some new faces. I greet you on behalf of my own center, the International Center for Law and Religion Studies, and also as president of the International Consortium for Law and Religion Studies based in Milan. Well, this is the first time I've visited Armenia. It's not for lack of trying earlier. I was supposed to come to a conference in 2007, I believe it was, and I had reached Spain and got word that a close colleague had died and I had to go back to the United States. We've also had, over the years, several people come to our conference at BYU in the fall. We've had at least 9 or 10 people over the years from Armenia, and I see some of them here in the room with us. So, very grateful to be here. I have to say that in some ways one of my first contacts with Armenia was that my younger brother's father-in-law, John Huntsman, was engaged in building a cement factory immediately after the 1988 earthquake here. And I know my brother came here at that time when it was being set up. And I understand that's had some helpful influence over the years in rebuilding and having an impact on this country. So that was another direct tie to Armenia. Now, during the years immediately after the Armenian earthquake, the world experienced one of the major political earthquakes of modern history, the collapse of the Soviet Union, and the emergence of an array of post-Soviet states. It's now been a quarter of a century since those seminal events, and what I wanted to do is reflect back, since much of my career has been tracking and in minor ways having an influence on what happened in this area since. I wanted to reflect back over those 25 years. I'd like to highlight some of the most significant legal developments that have emerged in the aftermath of the collapse of communism, and to identify some of the legal challenges moving forward. The first point I want to emphasize is that the 1990 political earthquake triggered a major constitutional moment in world history, possibly one of the most significant since the French Revolution. The most obvious consequence was the collapse of the Soviet Union, the independence of former satellite states in the Baltics and Central Europe, and the promotion of former republics of the Soviet Union to be independent states. For the most part, the transformation was remarkably peaceful, but it took violent twists with the disintegration of Yugoslavia, among other places. Significantly, this constitutional moment was felt in many other parts of the world, partially due to the collapse of support for many communist-leaning regimes elsewhere in the Third World, but also for independent reasons, such as the general rise of equality and non-discrimination, the rise of that paradigm in many legal settings across the world, the increasing salience of human rights rhetoric, and the resurgence at the same time of public religion in many parts of the world. So if you think about it, the same period saw the apartheid give way to a government committed to human rights in South Africa. There were harshly secularist regimes that gave way to more religion-sensitive regimes in Mexico, and in some ways a little later in Turkey. And when I was in Turkey about 2 weeks ago, and one of the interesting things, well, as you know, there's considerably considerable political fear of talking about the Armenian genocide in Turkey, but it's starting to be able to come to the surface. Bilgi University held a conference that named what happened by name. Some other things have been happening. Obviously, changes going on are not perfect. The constitutional changes that have been occurring obviously occur against a very long background with different political cultures in different areas of the world, different background conditions, different kinds of situations. But there were other things going on. In my own country, 1990 saw our Supreme Court, in my view, shocked American society by holding that aside from a few exceptional situations, general and neutral laws would override countervailing religious freedom claims. I remember reading that decision in April of 1990. I think it was the night before my first trip to Eastern Europe, and I remember hoping that Eastern Europeans would not read that decision for a very long time because I thought it was very problematic. Since 1990, in complex ways that I'm not going to go into, the federal Congress and the majority of American states have reversed much of the effect of that judicial decision, and we're continuing to see insistence on higher standards of protection of religious freedom in America. But this is an ongoing debate. And one of the things that's happening is that as one wrestles with these problems, you get more and more sort of countervailing pressures against claims for human rights in general and religious freedom in particular. A friend of mine, Andras Shayo, who's now on the European Court, has written what I think is a very intriguing paper called The Tragedy of Liberty. And the tragedy is that while liberty liberty in general and religious freedom in particular tends to be an abstract kind of norm, it comes up against more concrete political passions. And there's a tendency for the concrete political passion to overwhelm the desire for liberty, or to make it make sense to have sort of more restricted conceptions of the liberty, or for those other passions to overwhelm. If you think about this, this is a little bit like the great Dostoevsky story of the Grand Inquisitor, who comes back and is told that people would rather have bread than liberty and religious freedom, and to assert that kind of freedom. Well, I think one of the things that happens is that you have a general claim for religious freedom, and then it comes up against, it's not that anyone challenges the notion of that norm itself. What happens is that it gradually gets eroded by exceptions. Exceptions made in the name of other state interests, security, for example, legitimate interests, by the way. It sometimes comes up against new or competing rights. It comes up against challenges in the way the judiciary conceptualizes and controls the balance, and in all of these ways, rights can be chipped away at. Now, my own sense of what's happening, I remember the early days of the 1990s. It was a time of great euphoria, of hope, of a sense of openness. I remember, I'm basically a German scholar, and I remember the wall coming down in Berlin and the pictures of people surging back and forth. And I remember the early 90s with substantially new religious freedom laws in most of this region. Many of you worked on those laws. And then gradually we started to see patterns of retrenchment. I think of the 1997 law in Russia, which many of us worried at the time would be very problematic. In fact, it turned out not to be as problematic as it might have been because of, I think, some enlightened bureaucrats and people who understood and people who didn't push that law to extremes. But there's this pattern, and one of the other parts of the pattern that I want to stress is kind of return from the dramatic constitutional moment to the more normal politics of day-to-day engagement, balancing, assessment of new concrete problems, and so forth. And I think what I want to stress, and that the real ultimate point of what I'm talking about, is the importance of continuing to work and to endure and to work in a more, let's call it a more normal setting, to wrestle in an ongoing ways, to prevent the tragedy of liberty from setting in, to make sure that that appropriate forms of liberty do prevail. And part of the point of what I'm going to say, and I'll try not to go into too much detail, but in area after area, what we've seen happening is the formation of much better legal tools to accomplish that end. They're often not dramatic tools. They're tools that one works with in normal and day-to-day life. So let me talk about some of these. One that I've actually worked on a fair amount myself over the past 25 years is the right of religious communities to acquire legal entity status. I often tell my students that this is not a right that people make television shows about. It's not necessarily dramatic. Indeed, one actually hopes that laws in this area will be passed in ways that are not politicized, because in many ways these ought to be easy and consensus rules. They're often technical, but let me just describe briefly some of the high points in the evolution in this area. I remember being tasked in the late 1990s by an OSCE panel on freedom of religion that I was a member of, with writing a little booklet on the ways that the laws governing structuring of religious communities. Now, so I wrote this little booklet, published in 1998 or 1999, and I remember at the time there were really only 3 cases in the European Court of Human Rights on this issue. There were really no cases in the United States, or for that matter in Western Europe, because this issue was such an easy question. If you want to register a religious organization in the United States, you create a short legal document, take it to the state authorities, they stamp it, and after about 15 minutes, the group is registered. And since it's so easy, no one was bringing cases about this. In fact, I remember I got my son at the time, who was at Yale Law School, to write a paper on this issue of the right to a legal entity status. And his professor said, "Why on earth are you worried about this? No one has any problems here." But of course, in many parts of the world, there were severe problems, and that was the issue. Okay, so at the time I wrote this first book, there were these 3 cases, none of which actually involved a religious community. By 2004, the OSCE, the Organization for Security and Cooperation in Europe, the advisory council that I was a member of published a small booklet on guidelines that should be used with respect to legislation. This grew out of the fact that we had been tasked over the past, at that time, the past 5 or 6 years, with responding to a lot of new laws that were emerging around the region, primarily east of Vienna. And we had the experience of working with, commenting on those laws, bringing to bear some of the international instruments and also OSCE commitments to work on these laws. And we had a lot of practical experience with where the difficulties were, with where the problems were. And I remember we published a set of guidelines in 2004. These were endorsed by the Venice Commission, by the UN Special Rapporteur on freedom of religion or belief. And they started to lay out in some detail the kinds of things that should be possible for religious communities to get as part of working on their religious affairs. Now, by that time, we had had the Moldova case, the Metropolitan Church of Bessarabia versus Moldova, which clearly held that a religious community had a right to legal entity status, and when the government refused or rejected the application for that, that was a violation of human rights. But we still didn't have a lot of detail. What happened over the next 5 or 6 years is we started getting a series of cases, and I'm not going to go into detail. One of my favorites was, well, I'll mention two. One was the Moscow branch of the Salvation Army, which had trouble registering under the new 1997 law. This was sort of tragically funny in a way, because the authorities would say, well, this must be a dangerous group. They wear uniforms, and there was a provision of the 1997 law that said the militant organizations should not be registered. And if you know anything about the Salvation Army, which people in other parts of the world did, this is a very peaceful group. They raise money at Christmas. They have some of the best anti-alcoholism programs in the world. So it was quite strange that they were not being registered. But there were some significant things that started coming out of cases like that. For example, the Salvation Army had some of its leaders in the UK, and they had listed some of the founding members of the organization in Russia as these citizens of the United Kingdom. The Russian law itself said you had to be a permanent resident of Russia, and one of the interesting things in that case is the European Court said, no, that's not a necessary requirement, and that was not a legitimate grounds for refusing registration to the Salvation Army. There were some other things that came out of that case. Let me just jump to the Scientology case, Church of Scientology, Moscow versus Russia. This is the case that the Scientologists were turned down at least 11 times by the time this case went to the European Court. And I think of this case as the case that describes 11 ways to fail in trying to register a church, all of which were held to be illegitimate and wrong. Some of the mistakes were repeated a number of times, but there were a number of things that were emphasized in this case, and this started to flesh out what this particular right meant. So first, the court emphasized the general principle that the right to entity status is linked to the underlying right of religious communities to religious autonomy, which I think is one of the really fundamental rights that has attracted strong support in the European Court over the recent years. Second, there was a refusal of an application, refusal of an application for registration was sufficient to make the Church of Scientology a victim within the statute. This is a more technical issue of what you needed for standing. The argument was, well, their earlier registration had never been formally dissolved, so they still had a legal entity, but the point was that the law required them to re-register under the new law, and the court said that was enough for them to have standing, in effect, to bring the new case. Third, as in the Salvation Army case, the European Court emphasized that government bureaucracy could not force the religious group to play an endless guessing game as to what was required. That is, part of what was happening is they would take in an application and the authorities would say, no, you haven't quite given us everything, so that they'd tell them something that they was missing. They'd go back, bring that back, and then say, well, there's something else that's missing, and then they'd bring that back. Well, there's still something else, and the court said, no, you can't force groups to play that endless guessing game. You have to be clear up front what's required, and once that's provided, registration should be granted. Fourth, the court emphasized that government officials could not deny registration for reasons that were really in the control of the government. One of the reasons that the Scientologists were not allowed to register on several occasions was they had not provided an original copy of the articles, the statute that the group had signed at their founding meeting. Well, there was a reason for this. They had turned in the original copy with their original application. And of course, they no longer had it. The government had it. And the government couldn't take the position that they had failed because of something that was in the government's control. Well, that gives you a range of ideas, but what was significant is we started to see, and I've just touched on a couple of cases, but there are now a whole set of cases that deal with registration issues. Let me mention one more that I think is very significant, the Messiah case from Moldova. In this case, some individuals were held, were convicted of a crime of having a religious service in someone's home without being registered. And the court held that, in effect, religious freedom is a fundamental right, it's a human right. Its exercise does not depend on grant from government to make that right effective, and it was a violation of the rights of individuals to be convicted merely because they hadn't been registered. In other words, and this is something that we had stressed for a long time at the OSCE, was that registration rules could not be made mandatory. That is, in the modern world, most religious groups want to register. It's much easier to work to open bank accounts, rent property, acquire property, all of those other kinds of things, if you have a legal entity. But there are some groups which, for conscientious reasons, or for simply, if they're small, for reasons of convenience, don't want to do this, and that should be left to the group. One other thing that I think was significant that came out of the cases was that it's not enough to give just a legal entity. You have to have a legal entity with appropriate powers so religious communities can carry out the full range of their activities. They're legitimate activities, activities that other religious or civil society groups can carry out. When the 1997 law was ultimately passed after the initial veto, there was a provision creating what I call limited power entities. That is, they were legal entities and they could tell the government that they existed, but there were a whole array of things that they couldn't do that were actually quite important for religious groups to function. And what's emerged in the case law is the notion that you have to have a right to a legal entity with sufficient powers to carry out the basic things that full range of things that religious communities do. Well, this is an example of one area, and I want to just highlight the fact that the OSCE in the past year has published an updated version of these norms called Guidelines Guidelines on the Legal Personality of Religious or Belief Communities. And I really encourage anyone working with these particular issues to get hold of that document and work with it, because it's I've touched on the tip of the iceberg here, but it covers the full range of what's happened. It pulls together sources from not only the OSCE commitments, but also the experience of the Venice Commission of the Council of Europe, which has analyzed a lot of legislation in this part of the world. It pulls together things that are endorsed by the UN Special Rapporteur, has good practice examples. It's a very powerful document. And so what I'm trying to portray with this picture is a gradual progression of the development as part of normal litigation, normal legal processes, of much more powerful and clear legal tools. Now, this is not the most dramatic example. As I say, there are many others. I think we're starting to see a number of interesting things happening. There is a case from Croatia about access to upper tier status. As you know, many of the countries of Europe have recognized different levels of treatment for different religious communities. And I remember being at a conference in the late 90s, and I had taken one of my good friends, Douglas Laycock, who's probably one of the leading European experts on church-state issues, and he listened to a day of people describing these systems, and in the afternoon he sort of looked out and people said, "Don't you realize this is discrimination?" Well, discrimination, there are different kinds of discrimination, and I often say we need to be discriminating about discrimination. If there are legitimate, objective grounds for differentiation of groups, which in many cases there may be, that can be legitimate, but it shouldn't be just invidious discrimination based on religious differences. There need to be objective and reasonable differences, and the court has started to find, for example, in this Croatian case, that there were some other groups that were denied access to the sort of the highest level of recognition. That carried with it right to hold schools, right to perform marriages. The court saw no reason why these particular groups had been excluded, and indeed there were some other groups that were really less qualified than the groups in question that were getting these privileges. And when the court sees those kinds of things, it really insists on a stronger notion of equality. A second example is from the recent Hungarian case. As many of you know, Hungary has deregistered a lot of the churches that had been registered originally in the 90s. And one of the really interesting paragraphs in that decision, paragraph 92, holds in effect that it recognizes that in many places having recognized status, would be Körperschaft des öffentlichen Rechts status, public corporation status in Germany, or recognized church status in Austria. There are a lot of different versions, but that can itself, that carries a kind of social prestige, reputation, and denial of that is not only discrimination of the group, but it's discrimination that interferes with religious freedom itself. So I think we're starting to see some more stronger equalitarian insistence. It's not going to dismantle church-state structures across Europe, but it's going to insist that these be neutral. Well, there are many other areas that I haven't touched on. We heard a little earlier about the very significant conscientious objection case, which was decided here but has been very significant across Europe. I know that it was controversial here. I think one of the interesting questions is going to be how that basic notion extends beyond issues like conscription and military service to rights of medical personnel who object to participating in different kinds of sensitive, ethically sensitive medical procedures, and how the notion of conscientious objection, how broad is that notion? That will be one of the things lying ahead. There have been the Nolan case, which was about a member of the Unification Church who had left Russia on a trip, left his child back in Russia, and when he got back to the passport control, was not allowed to go back in the country. The reason that was given was that he was a national security risk. When the court asked what was the security risk, the Russian government said it's a secret. This didn't fly well with the European court, but they said that even if it had been a national security risk, national security alone is not one of the listed grounds for overriding religious freedom. Obviously, a real threat to public safety would be, but a generalized national security claim that somehow this is weakening the unity of the country or something like that, that was not going to be enough. And that, I think, has profound significance for a number of religious workers for whom movement across boundaries is important. The need to have Catholic priests servicing congregations, say in Central Asia, a lot of different kinds of movements of religious groups. That's significant. There have been some very significant employment cases, and I think we'll start seeing those not only in the European Court of Justice, but in the European Court of Justice. So in all of these areas, there are increasing and better tools. The problems remain. The problems are not easy. They raise social tensions. But as one of my favorite cases from the European Court says, this is the Sarif case, paragraph 53, it's true that religious difference creates tensions, but the solution is not to eliminate pluralism, but to find ways for people to live together. And I think that's one of the key things as we return from high constitutional moments to more ordinary politics. It is people like those of us sitting in this room working steadily with increasingly useful tools to retain memory and to retain implementation of some of these ideals that are some of the key ideals that emerged from some of the most significant constitutional moments in history, but need diligence and constant effort if they are going to be effectively implemented. And I think it's my experience that it is precisely groups like this that really understand the issues, understand how important they are to society, and have the commitment and courage to work on them, that we really make a difference. So thank you very much. I hope this will provide at least one angle of perspective on what I look forward to as a very interesting conference. Thank you very much.